Hello friends. Today we are going to understand the topic the Payment of Wages Act 1936. First of all, we have to understand the definition of wages. Wages means all remuneration whether by way of salary, allowance or otherwise expressed in term of money or capable of being so expressed if the term of employment expresses or implied were fulfilled. B. Payable to a person employed in respect of his employment of work done in such employment. Basically, wages includes court settlement award, overtime holiday wages and leave period wages, additional remuneration, bonus, termination remuneration. Any additional remuneration payable under the terms of employment, whether called a bonus or by any other name. Wages does not include bonus or additional remuneration not as a part of terms of employment. House rent allowance. Perks like light, water, medical attendance or other service included from the calculation of wages by a general or special order of appropriate period. Provident funds, contribution by employee and interest of it, leave travel concession, gratuity, reimbursement of expenses. The object of the Act Payment of Wages Act 1936 central legislation and apply to whole of India. 2. Regulate the payment of wage to workers employed in certain specified industries to ensure a speedy and effective remedy to them against illegal deductions and unjustified delay caused in payment of wages. Act applied to the person employed in a factory, industrial or other establishments, a railway, whether directly or indirectly through subcontractor. Now, we are going to understand some sections of payment of wages. Section 3 deals with the responsibility for payment of wages. It means workers को payment कौन देगा? Every employer shall be responsible for the payment to person employed by him. That it is the duty of every employer to pay the wages to every employee. The second, for all wages required to be paid under the Act. However, in case of person employed in factories, manager of the factory, industrial or other establishment, if there is a person responsible to the employer for the supervision and control. Railway, the employer is the railway administration and the railway administration has nominated a person behalf of the local area. The contractor, a designated person by such contractor who is directly under his charge. Other cases, a designated person by the employer as a person responsible for complying with the provision of the Act. इसमें ये बताया गया है कि फैक्ट्री में मैनेजर, इंडस्ट्रियल अदर एस्टैब्लिशमेंट में जो पर्सन रिस्पॉन्सिबल है या किसी को अपॉइंट किया गया है Railway में employer or a nominated person. In the case of contractor, a designated person by the contractor. In other cases, a designated person appointed by an employer. Now, we are going to understand the section 5, timely payment of wages. Wages to be paid before expiry of 7th day of the month for railway, factory or industrial establishment with less than 100 employees. Wages to be paid before the expiry of the 10th day of the month for railway, factory or industrial establishment with more than 1000 employees. Wages to be paid before expiry of second day from the termination for terminated employees in currency coins or notes and by check or by crediting the wages in the employee's bank account amended in year 2017 कि एम्प्लॉय को वेजेस नोट्स में भी दिए जा सकते हैं, चेक में भी दिए जा सकते हैं, उनके बैंक अकाउंट में क्रेडिट करके भी दिए जा सकते हैं. Now we are going to understand the section 4, fixation of wage period. No wage period shall exceed 1 month. एक महीने के अंदर सैलरी देनी ही पड़ेगी. The time will not exceed for more than 1 month. The period responsible for payment of wages under section 3 shall fix wage period in respect of which wages shall be payable. Such wage period shall not in any case exceed 1 month. 1 month is the main note of this section. Section 7, deduction made for wages. The word deductions means workmen wages then can be deducted or not. Wages to the employee without deduction, but deduction which are authorized by the act, that is valid. That is fines, absence of duty, LIC premium, loan, membership, tax payable, and limitation on deduction, that are total amount of deduction in 1 month, not 75% in cooperative society, not 50% in remaining cases. If more than 50% by cleverness, then recovery of the wage will be taken back. If the deduction of the wages will be more than 50% by a conspiracy or by cleverness or by cheating of an employer, then the money will be given back to the employee. Deduction for recovery of loans made for any fund, deduction by order of court, deduction with consent, deduction for recovery of losses. Section 8 deals with the fine. The appropriate government approval required for the fine. That you cannot deduct the fine by your own. You have to take the approval of the appropriate government. Notice should be served in which all the act, omission, writing fines are returned. Employees should get opportunity of being heard. If employees do not get an opportunity of being heard, then fine will be void. As everyone should get an opportunity to heard. If an opportunity will not be granted, then the fine will be void. Total amount of fine is equal to maximum 3% of the wages of the employee for 1 month. Age less than 15 years, then you cannot impose fine. If the age is less than 15 years, does not mean the child labor. It means the age more than child labor and the age which is less than 15 years, the fine will not be imposed. If fine on employed person, then installment of fines or after the 19 days of the fine. The day on which fine was imposed, that is the happening of the event. On that day, the fine imposed from the happening of the event. Employed duty to maintain the record of the fine and then how to find and why deducted. That the employer have to maintain a proper record of every fine deducted on the employee. Section 9 deals with the deduction for absence from duty. If employee on, off, that is on holiday, then employee can deduct the wages of the days only by own will. Strike, maximum 8-day wages can be deducted. Section 10 deals with the deduction for wages or loss. And the employee should get an opportunity of being heard in this case, as the employee should know that the wages are being going to deduct by his salary. Section 11 deals with the deduction for service ended. The service means the value of service deducted into the employee's wages. That means a company gave a house to an employee that rents for amount rupees 5,000, and then the amount will be deducted from the salary or the wages of the employee. Section 12 deals with the deduction for recovery of advances. Section 12A, deduction for recovery of loan. Section 13 is deduction for repayment to cooperative society and insurance scheme. Section 13A deals with the maintenance of registers and record. That the employer has duty to maintain a proper records of the wages and of deductions. If he do not able to do so, then a proper investigation will be held to the employee as well. In the case of advance, loans, cooperative society and insurance schemes, the deductions will be made and the employee's deduction will be held and the deductions are valid. Thank you.